The 1994 amendment to Section 1124 of the Bankruptcy Code was a significant change in the law that affected how solvent companies could deal with their unsecured creditors in Chapter 11 cases. Before the amendment, Section 1124 allowed a class of claims or interests to be unimpaired under a plan if the plan provided the claimant with cash equal to the allowed amount of its claim. This option enabled solvent debtors to pay off their unsecured claims in full in cash without post-petition interest, which was often lower than the contractual interest rate. This option was seen as unfair by some creditors and courts, who argued that solvent debtors should not be able to avoid paying interest at the contract rate by filing for bankruptcy. The 1994 amendment removed this option from Section 1124 and left only two ways for a class of claims or interests to be unimpaired under a plan: either by leaving unaltered the legal, equitable, and contractual rights of the claimant, or by curing any default, reinstating the maturity, compensating for any damages or losses, and not otherwise altering the rights of the claimant. The amendment effectively eliminated the possibility of paying unsecured claims in full in cash without post-petition interest as a way of rendering them unimpaired. The impact of this amendment was that solvent debtors had to either pay post-petition interest at the contract rate or at an appropriate rate determined by the court to their unsecured creditors, or impair their claims and seek their acceptance of the plan. The amendment also increased the bargaining power of unsecured creditors in Chapter 11 cases involving solvent debtors, as they could demand higher interest rates or other concessions in exchange for their consent to impairment. The amendment also created some uncertainty and litigation over what constitutes an appropriate rate of post-petition interest for unimpaired claims, as different courts have applied different standards and methods to calculate it.